What's up, everybody? On today's video, we're going to break down the judge's ruling on the defense's survey that's gone out to all the jurors, asking questions that dig in to facts that have been disseminated by the media, some true, some not true. We watched the hearing. We got a little bit of a lean of what the judge was going to do, at least from what we thought. We made our predictions. And in today's video, we're going to see if we were right, if we were wrong, and if this was as big of a win for the defense that I'm seeing all over Twitter and all over the internet, everybody saying, whoa, big win for the defense here in this judge's order. Do I agree with that? Or is the judge looking ahead? All that and more. And of course, we'll look at your questions in the comments and focus in on everything you guys want to know about this order. All right, so this order was entered into the 19th day of April. I just saw it coming around Twitter and everywhere, and I was getting tagged in it yesterday. So I've just looked at it once. I've looked through it kind of really quick. And today we're going to dig into it, read every word, break it down a little more slowly. It seems like a win for the defense. So I'll just say a little spoiler alert. Okay, spoiler alert. The judge is going to allow the survey. He's going to allow them to continue asking these questions, including some of the gory details that people may not have known, but for being called by these surveyors, even including some facts that are not true. So why would the judge do that? Did he just believe the defense is expert? Did he agree with them? Does he think this is good for the defense? Does he think this is the only way to get a fair trial and to determine whether or not the jurors in Latah County are biased and what other county might work? Let's dig in. On March 22nd, the state filed a sealed motion for order prohibiting further contact with prospective jurors absent leave of the court. The same day, the defendant, Brian Kohberger, filed an objection to the state's motion with the promise of a forthcoming affidavit and memorandum in support of the objection. The court then entered a temporary order prohibiting both parties from contacting potential jurors about this case, including via third parties, until further order of the court. A hearing on the issue was set for April 4th. It's important for the judge to give this background because the defense said that he denied them due process, and he's saying, nah, this was due process. You got it. In the interim, the defense filed a memorandum in support of the objection to the state's motion for protective order, prohibiting contact with prospective jurors, absent leave of the court, with the declaration of Brian Edelman, PhD, attached, and a motion to rescind the order for failure to provide due process. On March 29th, the state filed a declaration in response to the defendant's motion to rescind order for failure to provide due process, a reply in support of the motion for order prohibiting contact with prospective jurors absent leave of the court, and an objection to defendant's motion to rescind order for failure to provide due process. On March 29th, the defense filed a reply in support of the motion to rescind the order for failure to provide due process. This is just procedural history. The court is letting everybody know what happened, how we got here, how everybody was given due process, frankly. And then we get to the hearing on April 4th, which we watched a lot of that together. And if you remember back, so just to recap where we thought this was going, I thought one of two things was going to happen. We all kind of agreed, I feel like, together as a community that the judge was going to let this survey go forward in some form or fashion. But we thought, based on the judge's questions to the expert and comments to the lawyers, one of two changes was going to be made. We either thought the judge was going to let the survey go forward without the questions that were false, the stalking and following on social media, things like that, or with some sort of opening line to say some of this might not be true, or these facts are actually false, something to not make the people think that this information is all true about Brian Kohberger and therefore potentially poisoning people that were not already poisoned or didn't already know about this stuff. That's kind of what we thought. We knew the survey was going to go forward. We thought there would be some kind of change to not disseminate false information. Seems logical. Let's see what happens. The April 4th, 2024 hearing was open to the public because neither party requested that hearing be sealed. Okay? That's an important line. That hearing, where the Latah County prosecutors read aloud what those questions were they're objecting to and didn't think should go out and be disseminated to the public. They read them aloud for everyone to hear, and then they read them into the court record. The court reporter was transcribing All of those questions are now part of the court record, which is very important as we continue through the judge's decision, which I thought is a very smart decision, by the way. At that time, the court heard arguments from both parties regarding a survey the defense had conducted in Latah County and wished to conduct in 2 additional counties. The state took issue with 9 of the questions in the survey, which were read into the record in open court. They were read into the record in open court and argued that asking those specific survey questions to potential jurors violated the court's revised amended non-dissemination order. Specifically, the non-dissemination order prevents the attorneys in this case or their agents from making out-of-court statements which a reasonable person would expect to be disseminated by means of public communication, and that relate to the following. 1, the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. And 2, any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. So it seems like some of these questions would at least potentially fall into one of those 2 categories. The state asserted the questions violated these provisions because the surveyors are agents of the defense and the defense bears the responsibility to honor the non-dissemination order. The defense argued that the questions in the survey were based on information obtained by defense expert Brian Edelman from reading and watching various news, articles, and broadcasts from both mainstream media and social media. The defense further argued that the questions did not violate the non-dissemination order because they constituted information contained in the public record. Okay, now we get into the argument of what is public record, what is not. We had our opinions. We used, things that would be defined as the public record in public records requests or public records exception for getting evidence in at trial. Seemed logical to use things the law already used to define public record. They used some different arguments here. Let's see what the judge says. The defense argued that the public record encompasses all information in the media for the public's consumption. The non-dissemination order expressly allows attorneys involved in the case and their agents to make extrajudicial statements, written or oral, concerning information contained in the public record. At the conclusion of the hearing, the court ruled the defendant's due process rights had not been violated. Let's reiterate that here. Because the order to pause the survey was entered after the defendant filed an objection, so the defendant had the opportunity to be heard. And the order was temporary. And the defendant was given notice and the opportunity to be heard at the hearing shortly after the temporary order was filed, and the judge said, we'll kick back all the deadlines a couple weeks. The Due Process Clause of the 14th Amendment to the United States Constitution provides that no state shall deprive any person of life, liberty, or property without due process of law. The right to procedural due process guaranteed under both the Idaho and United States Constitutions requires that a person involved in the judicial proceeding be given meaningful notice and a meaningful opportunity to be heard. So they were given notice and opportunity to be heard. The argument is whether or not it was meaningful. Due process requires that judicial proceedings be fundamentally fair. Procedural due process is not a rigid concept, but rather it is flexible and calls for such procedural protections as the particular situation demands. The court also kept the temporary order prohibiting contact with potential jurors in place and instructed defense counsel to consult with Brian Edelman to determine if there was a way the survey could continue while eliminating the concerning questions the state raised. The hearing was scheduled to continue on April 10th. That's when we brought Brian Edelman in. That was the second hearing that we covered. On April 10th, the parties again reconvened in open court. Again, neither party requested that the hearing be sealed. So we're going to talk about all this stuff in open court again, and it's absolutely going to be part of the public record at that point. The questions at issue were again discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumored in the media and on social media, while other questions were formulated based on information from the public probable cause affidavit filed by the state. After a lengthy hearing, the parties remained at odds over whether the 9 questions at issue should be allowed to be asked in the surveys conducted by the defense in other counties. So, court said, after all this time, all this discussion, multiple hearings, the defense and the prosecution could not come to an agreement about an edited version of this survey. The court tried. The court made some comments. The court thought maybe they'd be able to do this. He gave them some time even after the hearings. And hearing nothing and no compromise and no agreement, the judge is going to have to make an order. So this is not a bad thing. It's good for judges to push the parties to work things out. But at the end of the day, judges have to make decisions. And that's what Judge Judd did here. It's literally their job. So what did Judge decide? The public record, as the term used in the non-dissemination order, means the public court record, i.e. information from public hearings and from documents filed in the case that are not sealed. Okay, I agree with the court, but maybe it should have been written this way in the non-dissemination order. Lawyers, we're going to give grace here, but lawyers are supposed to be precise. Words are very important. Definitions are very important. And we need to try to get rid of any kind of argument or gray area as we can. Now, we can read the non-dissemination order, and any lawyer, including myself, that reads through a document, because of the way we're taught to think in law school and the way we think every day and how we work, we can pick out words that, oh, well, this could mean that, or this could mean this. In everyday language, people ask me stuff like this, whether it's a text message, whether it's a written contract they have with somebody, whether it's a handshake agreement where somebody said this, somebody said that, whether it's church bylaws. There are multiple ways you can define and dissect and break down things in different ways, because words are important and some words have multiple meanings. And two people can see words and phrases defined different ways. Now, while I think it's a fair definition to say it's the public court record, and again, I would use other legal uses of public records to give me some credence, but no matter how you look at it, the court probably should have been a little more specific and said public court record. We'll give them grace, and it's up to the court, and the court's defining it now and adding that language in now. And that's how we're going to view this non-dissemination order going forward. And I would say the court should probably make an amended non-dissemination order to put public court record in there. Number 2, information that formed the basis for the 6 of the 9 questions at issue came from the probable cause affidavit, a document filed in this case and is not sealed. So boom, all of those are part of the court record. We knew those were going to be allowed. The non-dissemination order expressly allows attorneys involved in the case and their agents to make extrajudicial statements, written or order, concerning information contained in the public record. Additionally, one of the questions was not based on admissible or inadmissible evidence, but instead asked about feelings of members of the Moscow community. Therefore, the defense did not violate the non-dissemination order by asking 7 of the 9 questions. We knew that. We knew it was going to come down to the 2 questions. Now, he says those didn't violate the non-dissemination order. But what about the other 2? As to the remaining 2 questions, prior to the hearings, there was not information contained in the public record about these media items. Well, not with the public record as defined now by public court record. However, these questions have now been read into the public record and discussed at length during these hearings, including the fact that these media items may not be true. So what is this? To me, this sends a message to both sides, but especially to the state. If you want to try to read stuff into the public record that's bad for Brian Kohberger, or if you want to really pound your chest publicly, and I'm not saying they did that, but be careful, because once you do that, it's now in the public record and can be discussed by the defense or their agents. So frankly, the state made these questions public record and created a situation where now the judge can't say it violated the non-dissemination order because they're part of the public record. But kind of ipso facto, if you read here where it says, based on these 6 and 7 questions for these reasons, that they were in the probable cause affidavit, or really, not really evidence, because it just asked how you felt about members of the Moscow community. Those questions didn't violate. But potentially, if you would not have read them into the public record, maybe these 2 would have violated the non-dissemination order. But you've kind of removed the necessity of the court to make a ruling here. So the court's not going to say anybody violated the non-dissemination order if he doesn't have to, and he doesn't have to now that you've read these into the public record. Very interesting. Very interesting. So you read these into the public record, including the hearings, including the facts, these media items that may not be true. Because the information is now in the public record, the court does not see any benefit in preventing the defense from continuing its survey or requiring that the 2 questions at issue be eliminated. Ta-da! It's a great point. Something I didn't necessarily think of when we heard the hearing. They're public record now, so how can we possibly say it violates the non-dissemination order to ask these other 2 counties these questions? because Mr. Thompson has not just read them to people in Latah County or the 2 counties mentioned, but he's read it out to the whole world. Now everybody's seen it and everybody's heard it. Again, these questions and media items are now part of the public record, and the non-dissemination order does not prohibit the attorneys involved in the case or their agents from making extrajudicial statements about information contained in the public record. Okay, paragraph 4. The non-dissemination order also allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's clients. Any such statement shall be limited to such information as is necessary to mitigate the adverse publicity. Defense counsel argued at length that the 2 media items, these are the 2 questions, not contained in the public record. Again, the court is sticking to the fact that they were not in the public record prior to being read in by the prosecutor. At this hearing that nobody has to be sealed, it sounds like the judge would have granted an order to seal that hearing, by the way, as kind of a secondary issue. So we can see, I think the judge is going to be more liberal in allowing motions and hearings to be sealed than maybe we would have thought. The media items not contained in the public record were the subject of extensive media coverage that was prejudicial to the defendant, and that the survey questions asked potential jurors if they had seen or heard these media items was necessary to support the defendant's motion to change venue, which is aimed at mitigating the effects of prejudicial pretrial publicity on defendant's right to a fair trial. So he's saying, but maybe this violated the non-dissemination order, but it's a gray area, which is exactly what we said when we broke down the hearing, because you do have the opportunity to respond to negative publicity, especially if it's not true, and you didn't start the rumor, which the defense didn't. Could be argued. I'm not going to say the state did, but the defense, in putting that little video of Thompson saying, take a look at this and report on this, that maybe it was okay for the defense to talk about these items to respond to and protect their client's rights to mitigate recent adverse publicity. Paragraph 5. The goal of the non-dissemination order is to ensure a fair and impartial jury can be impaneled so that the defendant receives a fair trial. The court is focusing on the defendant's right to a fair trial. If defense counsel believes asking these survey questions, which arguably contain prejudicial information or misinformation about the defendant, is more beneficial than harmful. Again, if the defendant and defense counsel think this is good, exactly what we said in the hearing, it's like, this is kind of awkward because it's like you're kind of protecting the defendant from themselves, but they're saying, we know what we're doing, judge, and we want to do it. So if the defense really feels that way, well, as defense expert testified and agreed that that's how they felt, this court does not, at this juncture, have sufficient information or evidence to second guess that strategic decision by trial counsel. Sounds like a win. Listen, defense, we're here to protect your client's rights. So if you guys say this is how we protect your rights, even though it seems like it's doing the exact opposite, I'm not going to stop you. You're competent. You're capable. You're the public defender. Seems like you have unlimited resources to fight for your client. Well, guess what? If this is what you want to do, then so be it. But I can't help but feel a little bit of Pontius Pilate here, where the judge is kind of washing his hands of this, saying, you guys want to do this? Go ahead. Maybe he's handing them the rope, saying, go for it. If you think this is best, putting it into people's minds that maybe he did stalk people. Maybe he did follow them on social media. Because just because they've heard these things, the defense expert might say they're biased, but that doesn't mean the judge have to say they're biased. And I think we're all pretty confident we're moving towards a change of venue. But I think the judge is also saying here, you can't create your own problem. You can't say, because people have heard these questions now, because people have heard these facts in the way you want to ask them, without telling them it's not true, without cutting out those last 2 seemingly very prejudicial questions, if and when we pick a jury, either in Latah County or somewhere else, I better not hear that as an argument to strike a juror. that they're biased because they heard the defendant's survey, or they're biased because they've heard that Kohberger may have stalked people, but that doesn't affect their ability to be impartial. Just hearing something doesn't mean you can't put it out of your mind. Now, do I agree with that? Not necessarily. I think there are certain facts that absolutely make people prejudiced and biased. But I think the judge is kind of saying, here's the rope. You're not going to be able to use this as a sword and a shield. So tread lightly. Be careful what you wish for. You asked for it. Sometimes you got to learn the lesson the hard way. I feel just a little bit of that in this order. Now, I do think this is a win for the defense. The defense wants to do this. They're not just doing things flippantly. They have researched this. I think the expert absolutely had an effect on the judge. I think it was a great job by the expert at the hearing. And I think the expert's reasoning for why they're doing what they're doing, I think the judge took that to heart. I think that's the reason the judge is making the decisions the way he is. And I absolutely think this is a win for the defense. I think most of the titles are right. Most of the reporting, at least that I've seen on Twitter, I think is correct. I think this is a win for the defense. But I think they need to be careful. I think they need to step back and say, are we sure? When we move forward, make sure all of our moves are correct, strategic or otherwise. So it is a win, but just interesting, paragraph 5 there. Paragraph 6. The court's order prohibiting contact with prospective jurors until further order of the court is lifted, and the defense may continue its surveys without modification to the survey questions. Any extrajudicial statements by any attorneys involved in the case or their agents must continue to apply with the non-dissemination order and the new and improved definition of public record. Unmodified. So no removal of the 2 questions and no wind up or some of this stuff might be false or these 2 things are actually false. None of that. They don't have to do that. We were wrong. I'll say I was wrong in my prediction. I knew these surveys were going to go forward. I thought there would be some alteration, and there's not, because the judge is saying, you guys want to do this? The number one most protection in what we're discussing here in this survey and non-dissemination order is to protect the defendant's right to a fair trial. So this highlights the most important right. Everybody else has rights too. State has rights, victim has rights, judge has rights, witnesses have rights. But the number one most important right to protect through these pretrial proceedings is the defendant's right to a fair trial. And I know a lot of you are angry about that or don't like that in certain circumstances like this one potentially. I do like that. I think that's how it should be. And I think this is great. Remove another appellate issue. Look what they were able to do. They were able to call 1,200 people across 3 counties to try to find some unbiased jurors. It's really interesting to me how the judge decided to do this. And I agree with it. I like it. Let the defense do what they think is best for their client. Don't step in the defense's way. Let them do what they think is best. And again, because of some of the decisions made by the state, it doesn't violate the non-dissemination order anymore. Also, very clearly, the judge is going to allow continuances of their motion to change venue. So it is going to create some more delays. So if we were hoping for anything before March of 2025, that is completely out the window. That's why Ann Taylor and all these prior hearings says, if everything goes right. But as the state, this is just another miss. And I don't think the state was wrong here. I think this was okay to bring up. But it's another swing and a miss by the state where they tried to stop something that eventually the judge was like, no, the defense can keep doing this, whether it's discovery or now this. That created an unnecessary, 2, 3, 4 week delay. So guess what? Everything gets pushed now because the defense has had to waste more time fighting this, pausing these surveys. Now they got to pick them back up. And their experts still have to do their job, analyzing, summarizing before they can put together their motion to change venue and allow the state to respond, et cetera, et cetera. So more delays, which is no surprise because we knew that was coming as soon as they waived their right to a speedy trial. So I can't wait to read the comments and see what you guys think, what questions you have. If you think this was a win for the defense, a loss for the defense, if they should be nervous, if they should tread lightly, where you feel like Judge is at this point. Can't wait to read those and break those down with you. I appreciate you guys joining me. Don't forget to hit that like button. Subscribe to our page. I don't think I said hit the like button before, so hit it now. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.